David is a Commissioner with the Family Responsibilities Commission, also known as the FRC, in Townsville. Thanks, David. We'll hand it over to you.
Yes. Good morning. Thank you for the opportunity of making the presentation here. I was on leave and unable to attend in Cairns, where the Commission operates. The FRC thanks the Productivity Commission for its work and takes note of the important responses and its interim recommendations. The Family Responsibility Commission is a unique organisation established in 2008. It's a statutory entity of the Queensland Government whose purpose is to restore social norms and elder authority in 5 Indigenous communities of Mossman Gorge, Hopevale, Cowan, Arakoon and Doomadgee, where local commissioners conference community members who are failing to meet their social responsibilities. There are 26 Indigenous commissioners at the present time, all of whom sit alone now, and today commissioners in Doomadgee commence a 3-day hearing. In Mossman Gorge they sit today, and in Hopevale on Thursday. Each of those commissioners are respected members of the community and generally elders and traditional owners. They are paid the same as a board member, or about $500 a day for their sittings. They have the authority to issue income management orders in respect of a person's income if they fail to carry out their orders or recommendations. But to put that into perspective, there are approximately 2,400 welfare recipients in those 5 communities, and we currently have 128 income management orders. We consider the Commission to be a unique justice strategy because it's community specific and socially orientated. It integrates conferencing, referral for support services and case management. Those referrals are significant because if the referral agencies fail to respond, I have authority to report those service agencies to their authorities and eventually to publish in quarterly reports their failures. Local commissioners receive notifications at the FRC where community members are convicted of an offence, issued a domestic violence order or a breach of domestic violence order, they breach housing requirements or child safety requirements, or they fail to send their children to school for any more than 3 days. Accordingly, issues surrounding imprisonment and recidivism affects our clients and communities in many profound ways. These issues are not new. Gaps in support for both offenders and victims on release from prison exist. Lack of meaningful employment available within community. Lack of suitable housing in some occasions. Prison being considered a rite of passage rather than a deterrent for young people going to Cleveland or into the prison system. A lack of diversionary options and disconnection from family and the consequence impacts of that. Of significance in the 5 communities are the unintended consequences of blanket application of strong criminal sanctions. As noted in the FRC's earlier submission, domestic violence orders and breaches being inflexibly applied without consideration in circumstances in the remote communities results in disproportionate incarceration rates. High incidence of convictions relating to drug and alcohol and public nuisance charges also prevent community members from obtaining blue cards and limits employment opportunities. It is significant in relation to domestic violence matters, for which I'll refer shortly. Against this background, the FR supports the recommendations outlined in the draft report to reduce the scope of criminal offences and to expand diversionary options, including exploring orders to attend mediation. As noted in the FRC submission, domestic violence matters which occur between siblings and other family members would be far better dealt with Indigenous mediators or in settings such as FRC conferences. These options are either not canvassed by police or not available as a referral in the mechanism of the courts. This instance in Arakoon, for instance, when the Justice Department funded a mediation service, Quite often people involved in a one-off situation between siblings or between mother and son are not referred there. And as people do not turn up on those domestic violence applications, quite often they'll end up with a 5-year order. It's not uncommon for people in Arakoon to have 4 or 5 domestic violence orders against them. The FRC strongly supports the recommendations to include victim and focused restitution and restoration. And with restitution, we're not talking about money so much as about effort, doing some work for somebody where resources are limited. The FRC model of local commissioners conferencing community members who have done the wrong thing provides a forum to hold people accountable for their actions in a cultural appropriate way. As was said recently by the people before us, in an Aboriginal community of Arakoon of 1,300 people, or in Cone, which is a town of 300 people, everybody knows everybody's business. Privacy rules in juvenile justice are meaningless because everyone knows what's happened. And so as a consequence, there is a lot of local knowledge, and if you have strong local people actually conferencing those, everyone can be involved in those circumstances. At the present time, the Queensland Government considers the future of the FRC. It seems it is a significant opportunity to evolve and refresh the FRC model to incorporate alternate justice strategies which suits the needs of Aboriginal and Indigenous people. The FRC commissioners have established respected order and authority. They've been there for 10 years, standing in each community. They are an invaluable resource. Many of them, even though they impose income management orders, have been elected to local authorities, so that in Arakoon we have 4 commissioners, the 4 councillors. In Hopevale, one of the commissioners is a member of that council, and a number of people stood in Doomadgee who are unsuccessful. One option is for the FRC to take on a restorative justice conferencing role as trialled in Mornington Island and in Arakoon, and being used in a more widely in a juvenile justice process. Originally, the Commission had authority over juvenile justice, but with the election of the Palaszczuk government, that was removed on an election promise to moderate some of the legislative requirements of the Newman government. One of the uninterred consequences of that was to remove juvenile justice from our authority. However, notwithstanding that, if we receive a child safety notice, we can often bring in young people for conferencing with their parents. The proposal made in the Cape York Partnerships Palmer Future to merge the FRC and community justice groups to provide advice to and connect with case management in the court system would also serve to support breaking the cycle of imprisonment and recidivism. The local commissioners, along with the justice group, could contribute to the decision-making body in justice reinvestment strategies. Commissioners have a deep knowledge of the diverse changes within their community and the drivers of overrepresentation in the criminal justice system in each of their communities. Justice reinvestment is recognised as a potentially powerful factor in Indigenous community because of its capacity to embed local and culturally appropriate prevention, rehabilitation and diversion. There are a range of options available for use of the FRC to continue to make real change and contribute to improvements in imprisonment and recidivism in Indigenous communities. It will be up to the Queensland Government to recognise and embrace these opportunities. If I could move away from the FRC for one moment, I just returned from 5 weeks overseas to my home in Townsville, and the first 2 papers I read on Monday and Tuesday, apart from being dominated by electoral cycle, were dominated by the apparent crisis in juvenile crime within this community. I was appointed on Anzac Day 2008, and then at that time was the magistrate in charge in Townsville. About 18 years ago, and the lady in the back of the court, Linda, will remember, a meeting was held at the Garbutt Church of all Indigenous members of community and various groups, out of which the the Justice Group for Townsville was formed. It was operated by a young man who's since deceased, Kevin Nangu, and shortly thereafter we established the first youth Murray Court in Queensland and the Murray Courts. A number of the people in those days who were supportive of the Justice Group, who are now passed on, Alice Dowden, Elsie Kennedy, Eric Durrell, and there are a number, like Linda here today, Coralie Cassidy and Eva Kennedy. I think if they read the papers today would be appalled at what has happened. I just finally wish to say that I always believe that when a young person comes to court for the first occasion, it's an indication the whole system has failed. Either the parents, education, child safety, the community itself, police, the whole of those things. Once that person returns on a second occasion, there is no doubt the system has failed. It's time, I think, that the whole community took responsibility, and there are very generous people within the community who can make voluntary contributions to those things. I've now returned to Townsville. I hope to take some part in assisting the justice groups in my retirement, which will come in the next couple of months. But I think the model of the FRC and the use of Indigenous people, particularly within communities, where, as I've said, most people know exactly what's going on, and that authority level, particularly with the backup of possible income management, but I've said 128 people and 2,400 is not an overkill. So, extending beyond my brief today, I am somewhat disappointed what I hear about Townsville.
Thank you. And the FRC is an interesting model. We will have some questions on the FRC model, no doubt about that. Can I just pick up your almost closing comments? And in some ways you echo Wayne Parker, who talked a lot about the coming together. When you say you read the news here and you're disappointed about where the young people's offending has gone and the need for the community to sort of, get behind this, what needs to be done, in your humble opinion?
Well,
You've got a unique background. It's probably useful here.
Well, I think, first of all, the press needs to be more responsive. Youth justice crime in Townsville is not at academic levels. It's actually been decreasing over periods of years. And if you take into account in 2015, when the age was increased to 18, you'd accept there would be some increase. But proportionally, it's not as one would read in the papers.
Out of control?
No, I wouldn't have thought so. But I haven't lived here for a long time. But Linda and people from the Justice Group can tell you what is the real problem is children repeating themselves and then going further and further into more serious crime. And that means that the system is failing them.
What can we do? How can we help?
Well, as in every community that I've been, parents are primarily responsible, and they have let the side down, as the elders here have said today.
Yeah.
So it's to make them a little bit more responsible.
Yeah.
We have that stick of income management, which does work, and it brings people to heel. At least they come and sit. But it's more important, I think, to have a system where the parents and the children sit together with those authorities to try and work out a solution. Because child safety can have a solution, but if they go back to an environment which is unfriendly and kids are happier to be away from it, just go back for a feed, that's not going to solve the problem. So I think, there has to be some work with parents. I think I found the police very, very helpful. Linda was a community police officer when I first started and was very supportive for us for the courts. And having more Indigenous community police officers would be a great help, I think, within the community. Having those courts being more open to elders and to advice, but also one of the issues that needs to be faced is youth justice. Caseworkers have huge overloads. Their casework numbers are about, the last time I looked, about twice the amount of a Victorian's caseworker. Child safety are similarly that involved. whilst that is a great cost to do things, but if you can bring other people within the system, elders, volunteers, people from justice groups to be more directly involved. And one of the issues that really face us a problem in the community is that all penalties in relation to juvenile justice, by the time they're imposed, by the time the kids get back from Cleveland, the time limits are gone. And because people visit the communities on a regular basis, even with good intent to have community service and those orders undertaken, unless you have local people to do that, and do that immediately a child comes back from detention, and have them involved in the community, there's a distance of, can be months before people get involved. And then the whole idea of what is this child being punished for when in the meantime there's 3 or 4 more offences.
Yeah.
It just combines together. That's for those under 18, but the older young people who go straight to Lotus or to your prison here, they need to be looked at once they return to the community. And I found that if you, with the system trialled in Arakoon, if you looked at the breach of parole and the return to prison and the cost of doing that, it's quite phenomenal. If you can break that and get people to spend a little more time working their parole within community, that's a great investment.
Yeah, that's good advice. Thank you, David. I want to ask and for you to explore out a bit more around the Murray Courts and the Family Responsibility Commissions, and if you think, they exist well together within the same community context, and additionally, or can they exist together in the same context, and in addition to that, do you think that these initiatives, which are full-on programs now, could be rolled out for the broader community? So beyond just Aboriginal and Torres Strait Islander communities, but the broader community.
When we established the Youth Murray Court, and Linda will remember this, and the Murray Courts, the courts were given no funds.
Yes.
So we did it all within the fund system, and we arranged for the justice group members who turned up. I think you got a meal allowance, did you? And they donated that back to the justice group. So it was volunteer based. And a great commitment from a lot of people. They worked very well. The Murray Court in Townsville was a peculiar case in the sense that you only went to the Murray Court if you were at risk of imprisonment, and that was determined by the lawyers and by the police. And so everyone who appeared there really knew that they were likely to go to jail. So we were looking for solutions at that time which would either suspend that for a period of time or provide an alternative. The funding for the justice group, for instance, just to monitor a period of suspended sentences was just not available. So I recall one day with the way Townsville is situated, someone living at the Upper Ross was late for court and turned up at 10 o'clock because he walked. At least he turned up. So when he's on parole or on probation, if he's got to go and report to in town to a probation office and doesn't have the funds, then they miss. So there's got to be a more flexible way of doing that, particularly with distances. Yeah. In the communities, it doesn't matter so much because you walk around there and do that, and there's no excuse. But I think there are a lot of things that I would like to have seen done here.
But if there's capacity to expand that model out, so you've reflected on how it was set up and what has happened. But if there's capacity to extend that beyond that and to look at extending Murray Courts and Family Responsibility Commissions beyond if someone's probably going or perhaps going to jail to a broader scope, do you think that would work?
Yes, one of the things that I have to say is that the successive Queensland government are quite mean in relation to supporting justice groups. They're totally underfunded. To get $120,000, which is roughly what they get to pay someone to be a full-time coordinator, run a vehicle and pay an office, it's almost impossible. It relies on volunteers all the time. My commission was based, when it was set up by the Anna Bligh and Jenny Macklin, was that people would be paid properly. So our commissioners are paid the same as a board member, $500 a day. So there is no excuse. They don't get paid unless they turn up. So I think it's time that the government took the view that if you're going to use people, you can't rely on the fact that they're on aged care, age pensions or whatever else. There'll be some volunteers, but there needs to be more money spent within the justice groups themselves to make them more viable. I think Linda, as a representative of the justice group here, would be able to tell you how tight everything is. And if you want to go and visit somebody who has failed to turn up, for instance, to a parole appointment, and he knows they're going to be arrested, just to go and visit them at the Upper Ross or Woollgaroo and spend the time to do that, just to bring them in and report in, is very time consuming when you're doing everything else.
David, do you think the models have the capacity, if there was funding, if there's capacity to broaden the scope and roll that out in the broader community beyond the Aboriginal and Torres Strait Islander community?
Oh, I think so. What wasn't covered when I was doing the Children's Court with Linda for that 5-year period, what wasn't covered, we could get plenty of people recognised as Indigenous, but we couldn't get retired Caucasian school teachers or someone who wanted to volunteer being recognised to look after the white kids, which these kids integrate amongst themselves, so it's not a division on race. So I was hopeful that we could develop that sort of volunteer basis. If you go out to Cleveland, it's just a mass of volunteers. You get people, retired mechanics out there teaching them how to strip a motor. You get the cowboys going out there. You get people volunteering all over the place. So there's a great resource that's not used, particularly within that court structure of the Murray courts and also the Children's Court, because they run together, basically. I think the community needs to take responsibility because, as I said, if you read the papers, everyone's out there ranting and raving as though you were in some sort of war. And there may be some of that, but it's not surely as serious as it prepares it daily in the paper. I invite you to get Mondays and Tuesdays' paper. You'd shake your head.
David, the FRC's been running 10 or 11 years. Should it run for another 10 or 11 at least? I mean, is there a role as an ongoing entity, or is this an intervention whose time perhaps is coming to an end?
I think the whole principle is something that can continue, but it should evolve. That if you're going to have a merger of justice groups and those and mediators together, there can be a really a saving in resources. And they can operate well within communities such as Doomadgee of 1,300 people or Arakoon, which are really self-contained communities. Acting outside that area with taking income management is a whole new thing because it needs to have federal government intervention. The Act was set up uniquely in Australia with the federal government giving the Commission authority with amendments to the racial discrimination legislation initially, and now it's a special measure. So it's nowhere else has that been done, and that authority be given solely to Indigenous people.
Elders in those communities that are involved in the FRC are being tasked with heavy responsibility, and I suspect from time to time we get some criticism from some in the community. It's a tough job. Will there be a next generation behind them that are prepared to stand up and take those sorts of roles?
One of the deficiencies of it was that when we were appointed, we were a 3-year trial.
Right.
And then subsequently we extended year by year. I asked successive governments to allow me to bring on new commissioners, but you're finishing at the end of the year was the answer.
Okay.
I think there are plenty of people who can do it.
Right.
Mainly women. The women are the strongest in the community. The men, one of our conditions of appointment is you can't have a domestic violence order against you in the last 5 years. And the way they hand it out now in communities, it just precludes many people. In the last time I sat in Doomadgee, visited Arakoon earlier this year, there were 3 people who came before me who had orders against their mothers because there was a fight. Now, they had 5-year orders. we sent those people to the mediations and resolved the issues. But how do you, in an Aboriginal community, apply to the court to get a domestic violence order removed? There are no lawyers, unless they're visiting. Police really object to any reduction of the domestic violence orders. So you can have one-off situations which might hold someone for 2 or 5 years. It really needs to be looked at in those unique situations where, as I said, you can have 4 or 5 orders on people.
I'd suggest to you that retirement might be a way off yet. There's more work to do.
Yes.
All right. That probably just about concludes.
I think, David, that was very useful and very helpful, and more power to you and the commissioners. I mean, I think it's a task that sounds like it needs to continue, and there are good people ready to follow on. Does the audience have any comments they'd like to make? Could you identify yourself?
Yes, my name's Carl McKenzie. I'm the Chair of Townsville Community Justice.
Just wait till we get the microphone, Carl. Thank you.
Well, Carl, you've got a loud voice. We've probably got it, but that'll help
Just
us.
for the purpose of the video.
Okay. Thank you. My name's Carl McKenzie, so I'm Chair of the Townsville Community Justice Group, and we have with us Uncle Alfred, who's a board member, Arnie Linda on the board, and our admin officer. I sit on the Queensland Parole Board. I've done that for about 7 years, and I also hear matters in QCAT, the MCD, Minor Civil Disputes. In light of the report that came out at the end of last year around the Youth Justice, Major General Stuart Smith, I think it was, one of the suggestions was Youth Murray Court, and we sat down and had a look at this, and we believe we have a slightly better way of doing the Youth Murray Court, which is to have 2 elders hear the matter, 2 JP elders, with then the other elders in the court, and then we have the police, prosecution, and also the legal advocate for the offender. The model we were looking at was not taking the high risk youth, but taking the entry-level youth, because that's where we feel we would have the greatest impact, and putting them on parenting programs, back to school programs, a whole range of programs. We have support from the Aboriginal Torres Strait Islander Legal Service for this model. We also have support from Queensland Legal Aid, the Senior Registrar, the police prosecutors are even talking about hearing police cautions as well. But we think it'd be very powerful to have the Murray Court run by 2 Murray JPs, because we can sit there and say, look, we know your grandmother, Billy, and she'd be very disappointed. But the other difference we would have here in Townsville as opposed to the remote communities, which I was just listening to, the difficulties are there. It's a very homogenised community. Townsville is really a hub. We have the 2 Indigenous groups, Bindal and Wulgurukaba, but we also have within here Indigenous people like myself. I came up here with the military in 1982. I'm of Koori heritage. We have this young lady here who's from Mount Isa. What's your country, Auntie? Cardwell. So we're not as homogenised, so we can hear these matters and not have that problem of crossover that you were talking about. The only real impediment is that to do this, they would probably have to extend the boundary of maybe Palm Island community to include the Townsville region on, say, a 2-year evaluation, or make it an exemption area. But we even have a court ready to go. QCAT has room for us to use that court twice a month. So we've done a study on this, and we're presenting to the department hopefully in a few weeks.
The question is with government now to decide to proceed.
Absolutely. It's in the government's hands. We've got a package ready to go, and the elders are willing to work in that court over the 2-year evaluation for nothing. We are so worried about our youth that we're willing to do this for free over the evaluation period to prove ourselves and to prove its worth. So that's something we would really like to put out there.
Thank you, Carl.
Yeah.
Thanks,
I'm
Carl.
going to draw the session to a close.
Okay.
Because we're due for a break now, and we'll reconvene around 1. I do want to thank you, David, for your presentation, and I know he's been with the Commission there for some time, and certainly also made statements and supported the work in providing a submission to the last inquiry that the Queensland Productivity Commission undertook, so thank you for that as well. But are you hanging around during the break? Yeah. So David will be around. I know people might have had some comments or questions of David, so please feel free to chase him up during lunch. For people who've come late, Commissioner Kim Wood and myself, Commissioner Bronwyn Fredericks, will also be around during the break to talk with people who've come to talk with us, okay, out of session. Thank you.
Thank you, David.